All right, so are we good? Yeah. All right, well, I'm ready when I am. That's great. Excellent. Okay. Good afternoon. I'm Brianna Nadeau, council member for Ward 1 and chairperson of the council's Committee on Public Works and Operations. Today is Thursday, November 21st, 2024, and I'm calling to order this hybrid additional meeting of the committee in room 120 and on the Zoom platform. The time is 2:04 p.m. For the record, I'd like to note that we have a quorum consisting of at-large Councilmember Robert White, Ward 2 Councilmember Brooke Pinto, and myself. Today, the committee will consider and vote on three measures: B25-0319, the Fairness and Human Rights Administration Amendment Act of 2024, B25-0416, the Department of For-Hire Vehicles Delivery Vehicle Traffic Enforcement Expansion Amendment Act of 2023, now known as the Carrier for Hire Oversight and Enforcement Amendment Act of 2024, and B25-0435, Fraudulent Vehicle Tag Enforcement Amendment Act of 2023, now known as the Fraudulent Vehicle Tag and Parking Enforcement Modernization Act of 2024. The first bill we will consider is the Fairness and Human Rights Administration Amendment Act of 2024. I introduced this bill on June 8th, 2023, along with co-introducers Councilmember Robert White, Zachary Parker, and Janice Lewis-George. The bill was subsequently referred to this committee, and a hearing was held on December 6th, 2023. The purpose of the Fairness and Human Rights Administration Amendment Act of 2024 is to make changes that will provide a fairer and more equitable justice system at the Office of Human Rights. One of the primary purposes of the bill is to enhance protections under the D.C. Human Rights Act of 1977 by broadening the scope of unlawful discriminatory practices under the statute's definition of sexual harassment to explicitly include those based on gender, sex, or sexual orientation, and gender identity or expression. The Supreme Court and the U.S. Court of Appeals for the D.C. Circuit have recognized harassment as a form of sexual discrimination that's prohibited under Title 7, and that sex-based conduct may create a hostile work environment, whether or not the conduct is sexual in nature. It's become apparent that the current definition of sexual harassment under the HRA, as being either conduct of a sexual nature or quid pro quo behavior, narrows the definition of sexual harassment as commonly understood and interpreted under the law. This runs counter to the consistent approach taken by the Council to ensure the HRA is written and interpreted to the broadest possible degree to prevent and remedy discrimination in all forms, including sexual harassment. Accordingly, the committee print expands the definition to include all gender-based harassment in the definition of sexual harassment, and not only harassment of a sexual nature as currently formulated. The committee print also grants an individual the right to withdraw their complaint at any time by filing a written notice of withdrawal with the office. Currently, after the Office of Human Rights investigates a discrimination complaint, it makes a preliminary finding of whether there's probable cause to believe that discrimination may have occurred. Once that preliminary finding is made, the complainant is locked into the agency's adjudication process. They often and unknowingly have made a choice which precludes the right to take HRA claims to court. If OHR issues a preliminary finding of no probable cause, the process comes to an end and the complainant's HRA claims are forever extinguished. If there's a finding of discrimination, the complainant may proceed to a time-consuming process of hearing before an administrative law judge and the Commission on Human Rights. This aspect of the HRA differs significantly from other jurisdictions that do not limit a complainant's right to vindicate claims of discrimination in court. For instance, under federal statutes such as Title VII of the Civil Rights Act, the Age Discrimination and Employment Act, or the Americans with Disabilities Act, discrimination complaints may always go to court regardless of whether the U.S. Employment Opportunity Commission issues a finding. Similarly, under Maryland state law, as well as under the Montgomery, Howard, and Prince George's counties anti-discrimination statutes, an individual may bring claims of discrimination in court after their human rights agencies have made a finding of no cause or cause. Advocates and stakeholders testified at the hearing for the bill that this has created a gap in access to justice. Many litigants filing discrimination cases at OHR are low-income litigants or non-native English speakers. While the adjudication process is challenging, even for some with legal counsel, it becomes untenable for unrepresented pro se low-wage workers who may unwittingly waive their right to a day in court. A pro se litigant may not even understand what evidence is relevant to their case until they go through the OHR process. Advocates and stakeholders testified at the hearing that their clients and individuals who come to them for help are typically unaware that after OHR investigates and makes a finding, then the complainant has at that point made an election of their available remedies. And by then, it's too late. They also may not be aware that if the Office of Human Rights makes a favorable probable cause determination, that they will have no right to bring their case before a DC jury, or that a preliminary determination against them extinguishes their HRA claims entirely. The director of OHR at the time of the hearing testified that the agency opposed this change because they believe it's inefficient and will undermine the principles of judicial economy. They noted that filing an administrative complaint is much like a trial in court. It's adversarial, consists of discovery, motions practice, and full examination of witnesses during the hearing. Therefore, the committee print adopts a middle approach for the withdrawal of complaints by granting litigants the right to withdraw their complaints at any time by submitting a written notice, following procedures set forth in the print, as well as by the agency, and provides the agency with enforcement power to take corrective actions if it finds any violations during the process. The purpose of this enforcement power is to deter attempts to withdraw complaints under coercion, undue influence, or forum shopping. The committee print also includes a new Section 306A in the HRA, which triggers events for issuing an individual notice of right to file a private cause of action. The office must serve notice whenever 1, the complainant submitted a written notice of withdrawal before the completion of the office's investigation, 2, the office dismissed the complaint, or 3, the office made a probable cause finding and the complainant filed a written notice of withdrawal on or before the 30th day after the close of discovery before the commission. The purpose is to allow complainants to exit the adjudication process at OHR early and pursue a private lawsuit in court, all without having to wait for the office's investigation to conclude. This ensures complainants are not locked into a potentially lengthy agency process if they prefer judicial resolution later. It also reduces the caseload burden on OHR by streamlining the process. Finally, the committee reworks the legal processes in Section 316 of the HRA to establish a private cause of action. The current statute provides a general framework but lacks procedural details for explicit situations such as timelines following dismissals or probable cause findings. With these changes, the legislation strengthens accountability and fairness in addressing discriminatory practices. Ultimately, the bill seeks to provide stronger protections for individuals, especially those complainants who represent themselves, more options. In return, this will create a more equitable adjudication process at OHR. My team worked very closely with OHR advocates and stakeholders to get this bill to a place where everyone felt comfortable, and I'm confident that this bill improves the protections and rights available under the DC Human Rights Act. The committee therefore recommends that the council approve B25-0319. Is there any discussion on the report or the print? Hearing none, I move to the committee print an accompanying report for B25-319 with leave for staff to make technical and conforming changes. All those in favor, please indicate by saying aye. Aye.
Aye.
The vote is unanimous. Thank you. Next, we'll consider the Department for Hire Vehicles Delivery Vehicle Traffic Enforcement Expansion Amendment Act of 2023. B25-416 was introduced on July 7th, 2023 by Councilmember Allen with me co-introducing. The purpose of this bill is to grant the Department for Hire Vehicles the authority to regulate food and parcel delivery activities. Council's voted 3 times to approve emergency and temporary legislation identical to this bill as introduced, and this bill would grant DFHV permanent authority that it's been operating under for close to 3 years. The bill as introduced was limited to enforcement of traffic violations in order to avoid a fiscal impact. For this permanent legislation, a more comprehensive approach is necessary. The committee print establishes carriers for hire as a new category of for hire service, including operators and companies, and assigns full oversight authority to DFHV. The growth of the carrier for hire industry has been meteoric, whether that's for restaurants, instant delivery of parcels, or groceries. Unfortunately, government has not kept pace with the industry. Companies are not required to register with the city, obtain an industry-specific license, or share data that might inform policymaking. It's very challenging to gain a clear understanding of the impact carrier for hire companies and operators have had on the district's economy and roadways. The current environment in DC is strongly reminiscent of the introduction of ride-hailing apps over a decade ago. These companies entered the local market as unregulated entities and were ultimately defined as a new class of private vehicles for hire with the passage of the Vehicle for Hire Innovation Amendment Act of 2014. Instead of reinventing the wheel, this committee print uses that law as a blueprint for carriers for hire. The committee print incorporates elements of another bill, B25-620, the For Hire Vehicle Trade Dress Requirement Enhancement Act of 2023. B25-620 was introduced on December 7th, 2023 by Councilmember Bonds, with Councilmembers Pinto, Louis George, and Gray co-introducing. The bill was specific to private vehicles for hire, updating requirements for displays of trade dress, which is a logo or insignia that indicates a vehicle is operating under a certain company. This is meant to ensure passenger safety and to facilitate street enforcement by making it clear what company a driver is working for. The committee print includes those proposed changes to trade dress requirements with some modifications. Under current law, there's no design consistency, which means some vehicles may be displaying a sheet of printed paper with the company name written on it, while others display a decal, magnet, or LED sign. This print fully standardizes this practice by requiring DFHV approval and requiring companies to provide approved trade dress to operators. The print also includes an option for DFHV to require that vehicles display a standard insignia confirming the company is fully licensed to operate in the district. With the emergence of vehicle for hire companies operating illegally in the district, this will help reduce the risk to riders by affirming to customers that a company is fully registered to operate in the city and in compliance with the law. As with the rest of the committee print, the updated requirements for vehicle trade dress are extended to carriers for hire. Operators who may be delivering on a bicycle or other two-wheeled vehicle must still display trade dress, but can do so on apparel or by other approved means. Carriers for hire use the same or similar mobile apps as the ones used by vehicles for hire. It makes no sense for DFHV to be able to regulate and enforce one, but not the other. And this committee print will give DFHV the authority it needs to properly oversee this growing industry and to enhance traffic safety by ensuring that carriers for hire are accountable to the rules of the road. With that, the committee recommends the council approve B25-0416. Is there any discussion on the report or print for B25-0416? Councilmember Pinto.
Great. Thank you so much, Chairwoman Nadeau, for you and your team and all of your work on this important bill. I know that this is of great interest to many residents and workers who are using these new modes of transportation or more frequently using seemingly these new modes of transportation as carriers for hire. I do just want to ask you about the enforcement protocol. So I hear you on the need to make sure it's consistent that Department of for Hire vehicles can enforce traffic violations. Do they have sufficient means to do so if a carrier is, for instance, not following the rules of the road or driving on a sidewalk? Does this in any way kind of undermine our ability to issue tickets or ensure that those rules are made very clear?
Thanks for the question. No, this definitely doesn't undermine anything else related to enforcement. This is specifically another tool for VIOs, and that's the enforcement agents for Department of for Hire vehicles, to have very clear guidelines. Their enforcement is really limited right now, very specifically under the law. And so this gives them more authority to regulate folks that are a part of this economy. And the trade dress piece of it actually helps a lot because there's sort of a binary there. And having been on a ride along with them, I can tell you they have things they look for, right? They're kind of like detectives on the road. They see someone getting out of a vehicle in the back seat and there's no trade dress in the window. They think, oh, I wonder what's going on there. Let's stop and talk to that driver. And then, just ensuring that they can have some authority when they're seeing delivery vehicles pull over, making sure they're not pulling over into an illegal spot, making sure they're not blocking traffic. So essentially gives us, it doesn't limit anything that DPW, for example, or MPD does right now, but it gives this core of employees very clear authority that they didn't have before, if that makes sense. And we added 2 more FTEs in this current fiscal year for that team.
Great. I was going to ask about that next. Okay, so the language of this bill adds another enforcement tool or authority as opposed to replaces the existing one.
Yeah, part of the problem is that there's just like, as new technology emerges around here, the law just doesn't speak to it. And so we want to make sure the law speaks to it. There's nothing that says DPW can't pull someone over or can't ticket someone that's doing something that's already not legal for anyone else. But having this extra layer, because Department of for Hire Vehicles is the regulatory agency for all of these companies and these drivers, it gives them someone else to answer to, because DPW has their hands full in general on parking enforcement. So,
or MPD in the case of
MPD, yes.
Okay. Okay, that sounds good. And thank you again. I do just want to kind of reiterate some of the concerns that I am hearing and seeing regularly around violations of traffic patterns. And this is certainly not unique to one type of road user, but we are seeing a lot of food deliveries and motorcycles, mopeds, being in one location together at once, oftentimes blocking ingress or egress on a sidewalk. And so I just want to use this as another PSA to folks listening that there is now a regulatory framework for this in place. We want everybody to get licensed. You'll talk a little bit about that, I'm sure, in the next bill with the fake tags, but we have rules of the road. We have laws that we all have to follow. And we need to make sure that those are honored and done so consistently. So thank you very much.
Thanks, Councilmember.
Thank you, Councilmember Nadeau, so much for your work on this bill. This is something that is top of mind for many residents in the city, and something I've raised concerns about before. And I just appreciate you doing work on this. I love so many of our residents being able to find work delivering food and using vehicles that are less harmful to the environment. The flip side of that, unfortunately, has been a lot of folks not following the traffic laws, and that creates a danger for everyone. Every time I'm driving, and I hear the same from a lot of residents, I'm concerned. I'm trying to look in every direction because there are a lot of scooters zipping around not following the rules. For those who are, they probably getting left behind too because it's taking them longer to make their deliveries. And so any system that encourages people to break the rules in a way that's dangerous is not good. And it is better that we nip this in the bud sooner than later before it becomes an entrenched part of driving culture in DC in a very dangerous way. So thank you so much to you and your team. I know there's some aspects of the bill that we're still going to try to work through between now and when the bill passes, but I'm really grateful, and I know many residents are, for you moving this bill forward. Thank you.
Thank you so much, Councilmember. So I now move to approve the committee print and accompanying report for B25-0416 with leave for staff to make technical and conforming changes. All those in favor, please indicate by saying aye.
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 Thank you. It is adopted unanimously. The final bill we'll consider is the Fraudulent Vehicle Tag Enforcement Amendment Act of 2023, now renamed the Fraudulent Vehicle Tag and Parking Enforcement Modernization Amendment Act of 2024. I introduced B25-0435 on July 14th, 2023, with Council members Henderson, Pinto, Allen Fruman, and Louis George co-introducing. The bill was referred to Committee on Public Works and Operations with comments from the Committee on Transportation and the Environment, and a hearing was held on November 1st, 2023. As introduced, the bill's intent is to address the significant proliferation of long-expired temporary tags, as well as outright counterfeit vehicle identification tags, as well as the intentional obscuring of plates to avoid accountability. Dangerous driving is a significant and rising concern in the district and requires a comprehensive approach to be addressed. This legislation addresses the proliferation of long-expired and counterfeit temporary vehicle tags, in addition to vehicles with plates that are intentionally obscured to avoid automated enforcement. The legislation gives the Department of Public Works and other enforcement agency authority to immediately tow and impound cars whose owners have blatantly flouted the laws by having clearly counterfeit, obscured, or long-expired tags. Under current law, even a vehicle with no license plates cannot be towed unless it has had 2 or more unpaid tickets. When a vehicle has no plate, it's hard to give it a ticket. It's hard to enforce speeding or a driver running a red light if the vehicle has an untraceable, fake, or obscured license plate. We cannot continue to allow car owners to buy untraceable tags or allow their tags to stay expired for months or years to evade accountability. Unfortunately, experience has shown that premeditated, reckless driving is often associated with vehicles that have these kinds of tags, making this legislation even more urgent as one of the tools we can employ to make our roads safer for residents and visitors. Traffic safety is public safety, and we address both with this legislation. This legislation would also empower DC government to proactively investigate and shut down dealers and distributors of falsified and counterfeit temporary tags, classifying that as an act of forgery. The district has established a traffic safety enforcement regime that is overwhelmingly reliant on automated traffic enforcement. This is clear when you look at the numbers. In-person citations for speeding violations make up less than 1% of all tickets issued. One of ATE's greatest advantages and weaknesses is that it effectively makes enforcement about the vehicle, not the driver. What that means is that parking enforcement, especially booting and impoundment, must be a primary accountability tool for traffic safety. This accountability falls apart if a vehicle and tag cannot be properly issued or issued a citation or tracked. The tools we have are flummoxed by a car with a cardboard license plate. This legislation amends the process, giving tow crane operators the ability and authority to immediately tow vehicles defined as unidentifiable. Now, you may notice the committee print is significantly longer than the bill as introduced. B25-0435 as introduced was entirely amendatory to existing law. In the markup process, however, it was clear that simply amending what we already had wasn't going to cut it. Assignment of parking enforcement functions to DPW is only evident in 2 words of a reorganization act from the 1980s. The district's specific authority to boot and tow vehicles come from 1 paragraph of the Traffic Act of 1925. Any other language governing parking enforcement is scattered elsewhere throughout the code, and the most recent law is now more than 20 years old. So we decided to start with a clean slate. Title I of the committee print, referred to on its own as the Parking Enforcement Modernization Amendment Act, or PEMA Act, is freestanding language that reorganizes existing law, including the recently passed STEER Act, into a new comprehensive statute governing parking enforcement, immobilization, and impoundment. Before anyone panics, approximately 70% of substantive text in the committee print is language that already exists in the DC Code. Parking enforcement as the tip of the spear of traffic safety is a refrain I've used since I started as chair of this committee. You might even say thesis statement. As such, it's appropriate for it to have an equally prominent place in the DC Code. Thankfully, over the last 2 years, DPW and the executive has begun to recognize the intersection of traffic safety and parking enforcement. The scofflaw pilot, currently being run by the city administrator, is a great example of what can be achieved when safety is appropriately prioritized. This committee print makes it so the thesis statement is fully reflected in DC law. To achieve this, the print builds on what Councilmember Allen established in the STEER Act, which created a new vehicle infraction point system to determine if a vehicle is eligible for booting or towing. Currently, for a vehicle to be boot or tow eligible, it must have 2 outstanding unpaid infractions of any kind. This committee print eliminates that 2-ticket standard entirely and establishes a fully points-based system, including for parking violations. This means we have flexibility to assign more points to safety-sensitive parking violations. One other major downside to current district law is that the 2-ticket standard for booting and towing penalizes many residents and visitors with booting or towing for minor parking infractions. According to current DC law, a vehicle with 2 parking tickets for overstaying a meter is as deserving of the impound lot as a vehicle with 10 speeding tickets. In effect, this targets consequences for those with the least ability to pay, rather than those who pose the greatest risk in road safety. This has had notable negative impacts on racial equity regarding who is impacted by parking enforcement without having a clear positive effect on traffic safety. There will be more policymaking on this matter in the years to come, and having a clean slate to work from will make it easier for the council to amend and for agencies and judicial bodies to enact and interpret. Legislation and laws that cannot be enforced are, of course, not very effective. This legislation puts teeth into requirements for registration and displaying current tags, which in turn allows DPW and DC Police to enforce parking and other laws, making our streets safer from road violence and sometimes other forms of criminal behavior. The committee therefore recommends the council approve B25-0435. Is there any discussion on the report or the print? Yes, Councilmember White.
Thank you, Councilmember Nadeau, for your work on yet another important topic that comes up a lot. I've gotten a number of complaints from residents about cars in their neighborhoods, sometimes sitting there for a long time, sometimes coming in and out. And we've seen increasing crime issues as a result of cars that don't have real plates. And so this is something that has become common knowledge for a lot of residents. And we need more opportunities to enforce this. After this bill passes, I intend to push our agencies to make sure they begin to implement and enforce this legislation, because passing it is very important. Implementation is the next very important step. So thank you very much. I look forward to supporting it.
Thank you very much. Okay. Hearing no further discussion, I move to approve the committee print and accompanying report for B25-0435 with leave for staff to make technical and conforming changes. All those in favor, please indicate by saying aye.
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 Great. The committee is unanimous. The motion is adopted. Is there any other business before the committee? There being no further business, the time is 12:29 p.m. and this meeting of the Committee on Public Works and Operations is adjourned.